Estoppel. The term estoppel derives from the Old French word estoppel, meaning to stop or to pluck. In legal terms, estoppel is a judicial device that prevents a person from asserting something contrary to what they have previously stated or agreed upon. Simply put, estoppel stops you from going back on your word when someone has relied on that word to their detriment. Legal definition. According to Section 115 of the Indian Evidence Act, when one person has, by his declaration, act, or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. This principle exists in various forms across common law jurisdictions worldwide. Types. There are several types of estoppel recognized in law. 1. Estoppel by record or judgment. This arises from judicial decisions. When a court has made a final decision on a matter, the parties cannot reopen the same issue in future proceedings. 2. Estoppel by deed. When parties enter into a formal deed, they are estopped from denying the facts stated within that deed. 3. Estoppel by conduct, also known as estoppel in pairs. This occurs when a person's conduct leads another to believe certain facts exist and act upon that belief. 4. Promissory estoppel. This equitable doctrine prevents a person from going back on a clear promise when the promisee has relied on that promise to their detriment. 5. Proprietary estoppel. This applies in property matters where someone is prevented from asserting their legal rights over property when they have allowed another to believe they have rights over that property. Essential elements. For estoppel to apply, certain essential elements must be present. 1. There must be a clear representation, whether by words, conduct, or silence. 2. The representation must be intended to be relied upon or made in circumstances where reliance was reasonably expected. 3. The person claiming estoppel must have actually relied on the representation. 4. This reliance must have led to a change in position or detriment to the person relying on it. 5. It must be unconscionable for the representer to go back on their representation. All these elements must coexist for the doctrine to apply. Promissory estoppel. Promissory estoppel is perhaps the most significant development in modern contract law. Unlike traditional estoppel, which relates to existing facts, promissory estoppel deals with future intentions. The landmark case of Central London Property Trust Limited versus High Trees House Limited in 1947 established this principle firmly in English law. In India, the Supreme Court has recognized promissory estoppel as a binding principle in numerous cases, including the famous Motilal Padampat Sugar Mills case and the Union of India versus Anglo-Afghan Agencies case. The doctrine ensures that when the government or a private party makes a promise expecting it to be acted upon and it is so acted upon, the promiser cannot later withdraw that promise if it would cause injustice. When estoppel does not apply? Estoppel is a powerful doctrine, but it has limitations. 1. Estoppel cannot override a statute or law. No agreement can stop the application of mandatory legal provisions. 2. Estoppel generally does not apply in criminal cases, as public policy demands truth in criminal proceedings. 3. Estoppel cannot be invoked against minors or persons lacking legal capacity.